Bienvenue à la réunion numéro.
Welcome to meeting number 104 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1083H and the motion adopted by the committee on Wednesday, December 6th, 2023, the committee is resuming today its study of the federal government's use of technological tools capable of extracting personal data from mobile devices and computers. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application.
I always do, for the sake of our interpreters and Mr. Light as well, just make sure you keep the microphone away from, or the earpiece away from the microphone so that we don't harm our interpreters. And I'd now like to welcome our first witness for this hour. As an individual, we've got Mr. Evan Light here, who is an associate professor. Mr. Light, I want to welcome you to committee. You have 5 minutes to address the committee. Go ahead. Start, please.
Bonjour, mesdames, messieurs.
Hello, everyone. My name is Evan Light, and I'm an associate professor at the Glendon College.
At York University's Glendon College. I'll give my remarks in English, but I welcome any comments or questions in French as well. I am, as one of you mentioned on Tuesday, the source of the documents with which Radio-Canada has been doing the reporting since November 2023 on the use of tools capable of extracting personal data from mobile devices and computers. The speed with which you've taken up the challenge of investigating widespread use of mobile forensic devices throughout the federal government is, for me, quite impressive and demonstrates a deep respect for the fundamental human right to privacy. Because privacy, it's not an abstract thing, it's a fundamental human right tied to other human rights. And in Canada, it's been a human right since 1977. We're talking about something that's quite fundamental. And for me, that means that it's a right that should not be violated unless we have a very good, well-documented reason to do so. I think the testimony that's been given to you by agencies so far hasn't necessarily shown that their use is what you can call necessary and proportionate, terms that have come up various times during your recent meetings. In summary, I see this committee, from 1977 forwards, we have really successive governments that have failed to protect our fundamental right to privacy. And I see this committee at this moment having a really great opportunity, not just an opportunity, but an obligation to step up and examine how government protects the fundamental right to privacy. I forwarded the committee numerous documents. Some have been translated, some have not, so you don't have everything I'll be talking to you about today. But I want to talk about these issues and get into some of the testimony from the agencies that you've spoken with so far. I first encountered these devices in 2020 when doing research for a course. A group in the United States had documented their use throughout over 2,000 police forces in the United States. There's been further documentation by the Carnegie Endowment in the United States documenting the use of these tools by various regimes throughout the world and how they're tightly integrated with the spyware. So a quick note on terminology, I don't see MFDs, mobile forensic devices, as being spyware. This has come up numerous times at this committee. But they have essentially the same capabilities. They're sold by the same suppliers. They're used by the same entities. I don't think we need to get hung up on terminology. I think that it's important that they are equally invasive and equally unregulated in their use, if not more widespread and more equally and unregulated in their use. So my concern is that not these devices exist, but that their use is completely unregulated. Various of the agencies that have testified to you have said they don't really know how they use them. They don't keep numbers. CBSA said, well, we use them all the time, but we can't tell you how many times we use them. Shared Services Canada on Tuesday testified, well, we don't have any actual policies or procedures on how we use them. Scott Jones decides as an individual when their use is warranted. So as noted by witnesses to this committee, the devices are relevant. They've been renewed many times. I believe one of Michel Mainville from the Transportation Safety Board, from The Competition Bureau on Tuesday mentioned that they've been using these devices since 1996, which was an amazing revelation for me, and shows really that these things have been used regularly by government for decades and have been unregulated until, well, it continued to be unregulated and without any oversight. Throughout the committee meetings related to the study, members of the committee and witnesses have used portions of or used the phrase necessary and proportionate. This phrase, I think, is really key to understanding the use of mobile forensic devices or any sort of surveillance technology by government. And it's actually tied to a document that came out in 2014, developed by 16 civil society organizations around the world. It's been endorsed by about 600 organizations and around 300,000 individuals, called Necessary and Proportionate International Principles on the Application of Human Rights to Communication Surveillance. With legal frameworks to work on, there are standards for understanding how to do surveillance while respecting human rights, something that I think Canada can learn from and maybe should do. I'll be quick, I'm almost at my 5 minutes. But I want to finish by saying that, well, quickly, a quick note on some of the recent testimony. Shared Services Canada and various other organizations have said that they only use mobile forensic devices in isolated labs, giving you the impression that they're really cut off from the world. This, based on the capabilities of the devices they own, is patently false. In the contracts that I forwarded to this committee, various entities, including CBSA, CRA, ECCC, the RCMP, and TSB, all have what's called UFED Cloud, which is a software package from Celebrate that lets someone essentially access any cloud applications that are on somebody's phone. So it's advertised as a way to get around warrants. In addition, and my last comment, various agencies have ruggedized versions of these devices. So ruggedized as in able to go out into the field and be dropped and thrown around. We would not be buying ruggedized devices if they were to be used only in isolated clinical labs. So I welcome any questions.
Thank you, Mr. Light, and appreciate got a little extra time there. That's okay. One witness. I don't mind giving a little extra to a single witness. The documents that Mr. Light referred to, there's literally thousands of them, and some of them are quite large. It would be quite the task to translate those documents, as you can imagine, but there are some documents that are being distributed to the committee based on what Mr. Light has provided us, so, and they are being translated. So we're going to start our first 6-minute round with Mr. Kirk. Go ahead, sir. 6 minutes.
Thank you very much, Mr. Chair, and thank you, Mr. Light, for coming here and for the information and the work that has led to this investigation. And I would just note, and I guess this is a request because it's tough sometimes to get to the meat of the matter within the time frame of questions, but you did mention that there's some recommendations on how government can ensure that rights are respected while investigations take place. So if I could ask if you could either send to the committee specific recommendations. Generally, a recommendation can be, a couple of sentences. And your expertise, if you could distill that to a point where then the committee could say, okay, here's something that we could recommend to the government. And I would also just note, for your information, Mr. Light, I filed what's called an order paper question asking for some more details on this over the extent of the entire government. I know 13 departments were highlighted. Shared Services Canada had indicated that there may be more than 13, so I have asked this question, and I'm hopeful that the government will be forthcoming in that information. I think they have 45 days to reply to that, so that's probably in about a month and a half. I do want to ask you, if I could, you talked about the right to privacy, and that's been a human right in Canada, or acknowledged as a human right in Canada since the 70s. One of the things that I've found very interesting and has led to a host of concerns is that differentiation that you have of these very powerful forensic tools for use for administrative purposes within the context of a department. So to look at an employee's device and an administrative investigation, something to that effect, versus a court-ordered or a investigative purposes for somebody who is not an employee of the department, didn't sign in a terms and conditions contract, but rather is subject of an investigation or periphery, a witness to an investigation. So could I ask you to expand a little bit on what the difference is and how one reconciles the difference between the use of these very, very powerful tools for administrative purposes within, say, a department or agency versus for investigations where they would be used on Canadians, whether with judicial authorization or the various other forms to which we've been told that they could be used?
Sure. So I think regarding use internally, I think that most of the agencies that have testified so far say we use them on our employees and we get their consent. I think that it's difficult, if not impossible, for employees to actually give informed consent in these situations, that there's an imbalance of power and there's an imbalance of knowledge. We've seen in the sessions of this committee just how difficult it is to explain what these devices are capable of. And consider if you were a junior employee and your manager says, we're going to use this device on your cell phone, you have no real alternative other than to say yes. And so I think that there's I think the use internally is quite fraught and imbalanced. In terms of its use with warrants, I think that there needs to be a step before you get to a warrant. That we should talk about necessary and proportionate. There are questions that we should ask: is this technology valid to be used to begin with? And this is where privacy impact systems come in, which personally I think are useless to a degree. They basically account to self-regulation right now, and so there's no process to which agencies or ministries are obliged to go through that would forbid them from using any technology. We saw this in Scott Jones's testimony on Tuesday, that he will buy this for anybody in government who wants it. There's no standard, which is mind-blowing.
It's interesting you bring that up, and I've been very I think forthright in my advice, and I think I reference it as unsolicited advice. Pick up the phone and call the privacy commissioner. We have an independent officer of Parliament. Any and all departments, agencies are a function of Parliament. I think often that gets forgotten. So specifically with privacy impact assessments, I think would you agree that if departments, agencies, and the government in general, if they were more forthcoming, doing things like privacy impact assessments, doing the outreach to the privacy commissioner prior to the use of these tools, do you think that would go a long way in helping ensure that the trust that I think Canadians expect that they should be able to have with government could be restored?
The Office of the Privacy Commissioner should be properly resourced and empowered with judicial authority and with proper financial resources to be a proactive regulator. That in the whole process of procurement, they should be the ones who decide whether technology should be used or not, and in what use cases. I think that agencies themselves are in a conflict of interest, really, when it comes to making their own decisions around whether things should be used or not. That there should be an objective arbiter, which should be the OPC.
Okay, you're suggesting going beyond the privacy impact assessment and ensuring that there is more steps and more tools that
Absolutely.
the
I
office has.
think privacy impact system is a useful tool for getting people, individuals, and agencies to think about these ideas. Yeah. I don't think it's a useful regulatory tool.
So if I could, just in the few seconds I have left, if you have those specific recommendations, please feel free to send them to the committee. Often, if it's a sentence or two that articulates exactly what you've suggested, and with your expertise and background as well, you're welcome to send supporting documents as well. And I know that there's a ton of other information, but please feel empowered that you're welcome to send that to the committee after your testimony here today.
Thank you, Mr. Kurek. Mr. Light, generally what we try to do at committee is set a deadline on when that information can be provided. So I'm going to set that deadline for a week from today at 5 o'clock. If the clerk will follow up with you and just let you know, remind you what Mr. Kurek's request was. 6 minutes, Mr. Housefather. Go ahead, please.
Okay. Thank you, Mr. Chair. Thank you, Mr. Light, for being here today. You were quoted in the CBC story as saying that you were troubled, deeply worried, I guess, by the information that I presume you were presented by the reporter about the PIAs not being done in the 13 departments. You've heard, I imagine, the testimony from the different departments. You don't in any way deny or disagree with their assessment that they're not using spyware or malware and seeking to spy on Canadians at large, correct?
I have no evidence that would point one way or the other. I haven't done that research. I've done some. I mean, procurement is a difficult sort of research to do. We work on contracts that are out there on public record. I think a lot of spyware companies sell their wares through third parties, and so that it's actual difficult research to do within government. But in the data that I've had, I haven't seen anything one way or the other, and I cannot.
No, but I mean, they've testified that they don't use it. You have nothing whatsoever to contradict that testimony, correct?
No.
No. Okay. So you have no basis to state the opposite, is what you're saying. You just don't know. You're saying that you can't be sure their testimony was truthful.
Exactly.
Okay. And with respect to data extraction technology, you have to have the device in your possession. You agree with that, right? That's not spyware or malware.
You need to have the device initially. There are hardware components to mobile reference devices that enable creating an image from a phone. So imagine you're pulled over, you're at the border, and you ask for your phone. It can take maybe 5 minutes to make a copy of somebody's phone. And then you have an image, just like a CD image, that can be shared between agencies, that it can be put on a USB drive. Data, it becomes a portable thing.
But now you're saying that people are acting completely outside of the law and the limit of a warrant and the limit of their authority to do that. You've had no testimony that has ever shown that any of that has happened, correct?
Correct.
You have no basis to say that other than your supposition that this is hypothetically possible.
Correct. As well, I'm going on the basis of just the capabilities of these technologies and what they're advertised for. So, for instance, if you look into the Celebrate marketing materials, they advertise their cloud capabilities as ways to work around warrants. That in the past, you would need to get a warrant to use anybody's cloud account, to access their banking through their phone, to access their Google Maps, their GPS history, et cetera. With the cloud functionality that I mentioned these 5 agencies have, they advertise as a way to work around warrants, and you no longer need a warrant. You just need the phone or an image of the phone.
I understand hypothetically what could be done with the technology. All I'm substantiating is you've had multiple people here that have testified, and none of them have said any of these things. And they're, as you know, when you're at a committee, whether you're sworn in or not, you're being held to tell the truth under penalty of perjury, or penalty of contempt of Parliament. So nobody has testified to this. In fact, I think I'm just going to read what the CBSA said. Devices examined by the CBSA's digital forensic teams have been seized pursuant to specific court orders, such as search warrants or judicial authorizations issued to CBSA investigators. The data extracted from seized digital devices is processed only within the CBSA's own digital forensic laboratories and is provided only to those having lawful authority to access that data. I'd also like to clarify that spyware is typically defined as software installed in a device for the purposes of covertly intercepting, monitoring, and/or gathering a user's activities or data. I want to assure the committee and the Canadian public that digital forensic tools utilized by the CBSA's investigators are not spyware. We use digital forensic hardware and software to unlock and decrypt seized digital devices as an important tool in our efforts to enforce border-related legislation to protect Canadians. You have no basis to dispute any of the things that are said there, do you?
No, I don't.
Okay. See, all I want to establish is that I understand, right? This is really scary technology to a lot of people. And if it were used improperly, and we need to have safeguards to make sure it's not used improperly, there are a lot of bad things that can happen. But we have no evidence of that, and I don't want to scare Canadians into believing that that's actually happening.
At the same time, we don't have necessarily any oversight or transparency on the use of these tools going back almost 4 years now.
Well, I mean, that's your contention. I would say that we actually do have oversight based on the heads of the departments and people that are, again, under pretty strong ethical rules to comply. But I get what you're saying, that of course there's fears, and we have to make sure, and our job as a committee is to make recommendations to make sure that our policies and regulations are in place to mitigate any concerns that may exist. Do I have any time, Mr. Chair?
Point of order. I'm wondering if Mr. Housefather wishes to become a witness, and we can cross-examine him, because he's certainly giving evidence that this.
That's not a point of order.
He's not
That's
given.
not a point of order.
He's giving evidence that this committee is not heard through witnesses.
We're stopping
That's
this.
not
I actually just read from the witness's testimony.
Hold on, Mr. Housefather. That's not a point of order, Mr. Brock. Mr. Housefather has the floor, and like all members, he's entitled to give his opinion, his comments, and ask his questions. And as members of the committee know, members' time is their time. And go ahead, Mr. House.
Mr. Chair?
I stopped it at 1:14.
114, okay. Thank you. And I appreciate my colleague, Mr. Brock's comments. I mean, I think he is probably the person that would be the most verbose in terms of giving his opinions about things. So I'm so a little surprised. But coming back to you, Mr. Light, on a larger question, and I understand again the many issues that you've raised in your literature, and I'm looking forward to getting the translated copies when we get them. We haven't gotten them yet. If you had one recommendation that you wanted to give to change existing Treasury Board policies or existing policies, what would it be? Like your primary one?
I would say that privacy impact assessments coming from the Treasury Board should be mandatory in law, but also should come before anything is purchased. To date, in my broader research, we've asked for around 250, 300 ATIPs, hundreds of contracts, adding up to about $800 million worth of purchases related to surveillance. It's a huge amount of money. And just recently, I got an updated contract from Keel Technologies for mobile forensic devices. The Copyright Board was a new agency that came up as a receiver of these things for $11 million, a recent contract, a renewal. So I think that if we're going to be careful with money, that we should really ask hard questions about what technology is purchased before it's purchased.
Thank you. Thank you, Mr. Chair.
Merci, Monsieur Housefather, Mr. Light. Juste pour les membres.
For the benefit of the members and for the interpreters, if we could perhaps speak a little more slowly, because we are...
True or no? Right, if we can... For the interpreters, if you don't mind. Thank you so much. Monsieur Villemure, pour 6 minutes. Commencez, s'il vous plaît.
Mr. Villemure, you have 6 minutes. Thank you very much, Mr. Chair. Thank you, Mr. Light, for being here this morning. As you know, your work has led to the writing of this article that has led to this meeting. What we've heard in terms of testimony has been quite similar. People have said we required this tool. We had already looked into it in the past. We didn't do privacy impact assessment. It seems necessary, and we'll do that. That's more or less the tenor of what we've heard. Would you feel that that is something to be expected before a committee like this one? No, not as far as I'm concerned. If you look at the original CBC article from November, I was referring to standard or normalization of surveillance within government.
About for me, what seemed to be a normalization of surveillance within government.
I'm concerned by this because surveillance, it's just not right that it should be considered a norm. It should be an extraordinary thing. The right to privacy is fundamental. It needs to be protected by default. Most of the witnesses have said, listen, we asked for warrants, and so we are respecting the limits of these warrants. And then in questioning, I was wondering if that would be a good way, sort of similar to a privacy impact assessment, a proxy in a way. Should the privacy impact assessment come before a warrant or after it, or should it replace it? As far as I'm concerned, it has to come first. It should be something that should come first. Prior to a warrant, absolutely. Do you believe that if there were to be a change, a legislative change, that this privacy impact assessment should be made mandatory as a first step at all times? Yes. You were referring to proportionality. And on that point, so we were seeking information. Was that the only tool available to obtain the information in question? Or is it too invasive a process? That proportionality is something that you, as a term you used in your opening remarks. Could you elaborate a little bit on that? I think it's evident in the testimony, even from these agencies. On Tuesday, Scott Jones referred to, and Mr. Van Ville also spoke to the need for striking a balance between privacy and privacy violations of employees and the data that we need or that exists. So already there's an attempt to strike up this balance. If I use a government-issued device, my expectation of privacy is lessened, but it's not nil. No, not at all. You referred to the illegal use of a cloud, specifically Celebrate. Could you tell us a little bit more about that? Yes, absolutely. I'll do it in English so that I'm a bit more effective.
In the Celebrate and other companies, for instance, Magnet Forensics does this as well. We have the ability to extract what's called tokens. When you have apps on a phone that connect to the cloud, you have tokens that are essentially log you in. They serve as your identity, your unique identity to connect to a cloud service. In fact, Celebrate just updated their UFED cloud, which is being used by at least 5 or 6 agencies, so that it can access Lyft and Uber logs, it can access DJI drone flight logs, you can access banking, it can access your Google history, your GPS history. And so we're talking about things that in the past, we would need a warrant for each individual action to access each individual connection to a corporation. And maybe those corporations would be served with warrants and have to provide the information. Instead now, with a device or an image of a device, this information can be accessed without a warrant.
So we're talking about potential violations of privacy. Yes. The witnesses when we heard them, were saying, okay, we'll do a privacy impact assessment. And do you think it was negligence or an oversight, or what was it? Why did they not go ahead with these PIAs? I'm not trying to ascribe any motives, but I'm trying to understand what are the grounds for this. If it's just one isolated event, that's one thing. But if it's the entire agency, it's not just an oversight anymore. It's a problem. It can make sense. Fundamental rights are an essential thing. You referred to 13 organizations and departments. Have you since looked into other public organizations? You think there are more? In the contract I was mentioning earlier with Teal Technologies, recently Shared Services changed its practice, its procurement practices. So instead of purchasing things directly from Celebrate, they bought things from Teal Technology, TEEL, which is based in Victoria, BC. And in the contract, it's a contract that's due until 2024, April 2024, and the Copyright Board. So there are more than 13. I was quite concerned, actually, to hear Mr. Jones on Tuesday saying, oh, I can buy it anywhere from anyone. If you're in the government, you can simply order this and get it. Thank you very much.
Mr. Green, you have 6 minutes. Go ahead.
Thank you so much. I've taken a note from my good friend Renee's use of his iPad for timing, so hopefully I'll get it on, although certainly not to this expediency of my friend Mr. Housefather in the way in which he was able to deliver questions. So we're well into this, and one of the things that typically happens with expert testimony is they are given time to situate themselves in their subject matter expertise. In your opening remarks, you didn't have an opportunity to do that. I want to give you that opportunity now. I understand in your profile that you publish widely on issues of privacy, surveillance, and communications. And so perhaps as an opportunity to provide context to that, can you just share with what expertise you're here today?
Yeah. So I'm Associate Professor of Communication at York University's Glendon College. My background is actually in radio spectrum policy, which brought me into surveillance. A lot of the radio waves we use are also used for surveillance. I host an archive of the Edward Snowden documents. I, for about a decade now, have been heavily involved in research on surveillance and privacy issues.
And so would it be your contention that you're here as somebody that advocates for open and transparent government?
Absolutely. I also have an IT background. Before becoming an academic, I worked in IT for about 10 years. Ultimately, I ended my career in IT as Chief Network Technician of the McGill Faculty of Law. So I have an understanding from the, I guess, the back
A
end.
unique perspective,
Yeah.
it's fair to say. One of the things that strikes me as legislators here is that we're often tasked with trying to propound on technologies and subject matters that we don't have expertise in. I acknowledge that I don't have expertise in the things that you just stated you have expertise in. And so while it is true, there are good public servants who, to the best of their ability, are making judgments on a day-to-day about the privacy and proportionality of the tools they're using. Is it safe to say that the technology that you're referencing here would likely go beyond the scope of an average person in government and probably even around this table?
Absolutely. It's fairly esoteric stuff.
And sophisticated.
Yes.
And it was your contention earlier that one of the flags, I'll call it a red flag, you didn't use that, was that in reviewing the companies who have been procured, that they were actually marketing ways to surreptitiously backdoor devices to do things that they couldn't otherwise do directly through a warrant. Is that your assertion?
Yes.
And that's their own testimony, in fact, by their marketing materials.
Yes.
So that is a problem. That is a problem for me because I do rely on the testimony of people that are here, but I also wouldn't expect them to know all the ways in which the technology they procure could potentially impact their workers or the general public. And I reference all the ways in which data breaches happen by really high-tech companies and, in fact, government, where very sensitive information is shared very widely through malicious attacks. Do you, in your opinion, based on your subject matter expertise, have any concerns around the possibility for this technology to be used in ways that might lead to broader breaches in the privacy of individuals?
Absolutely. I think that talking about its use within or by federal government agencies is really the tip of the iceberg, that nobody, and myself, I haven't had a chance to date to look at the use of this technology among police forces throughout Canada at every level of government, and that there is a high level of possibility of abuse.
And one of the challenges we have, I would state, as my own opinion, in terms of the lack of trust and cynicism in government, and indeed in some spaces that creep over into conspiracies. As somebody who is also an open government advocate, would you agree with the notion that greater transparency, greater openness provides less room for conspiracy or cynicism? In other words, do open governments lead to greater trust in government institutions?
Absolutely.
And so when you're trying to track the procurement, because I was also on a file that dealt with government procurement, and I also found it very challenging. Can you just speak to some of the ways in which you have found it difficult to actually follow what the government is doing? So, for instance, in previous testimony, you may recall where I asked the procurement director, essentially, of a department, what the line item was on the technology. He couldn't reference it. And I also wanted to know what the line items for procurement was related to on-device technology, AKA spyware. So can you just talk to the ways in which it's very difficult, even with somebody with your own expertise, your own research background, to actually follow the bouncing ball when it comes to tracking exactly what the government is doing and where it's spending money and what it's spending money on?
Sure. So luckily, I have a research assistant who used to work in the private sector and wrote contracts with government, so she understands procurement at a degree that I did not. But here's how when we do this research, we essentially have a huge list of companies that we know produce really nothing but surveillance tools. And we dig through the open.canada.ca database of government contracts above $10,000. This only gives us access, to contracts above $10,000. Anything less than that isn't reported and isn't available to query. But even then, the comments, the descriptions of what the contracts are very generic. It's hard to actually parse through and see what is being used unless we file an ATIP. To date, over the last 3 years, we've filed hundreds of ATIPs. Our response rate has been about 37%. So we have hundreds of outstanding ATIPs for hundreds of millions of dollars worth of contracts.
And would that be in your concluding remarks? Would that not be solved by proactive disclosure on this stuff, databases that you could just go to and see rather than have to be forced to search through ATIPs?
Absolutely, and I've seen it done elsewhere. For instance, in Uruguay, in say the 2010s, they were developing really interesting open government technologies where you could see the spending on every ministry and department in real time.
Thank you.
You could track what was happening.
That's helpful. Thank you so much.
Thank you, Mr. Green and Mr. Light. That concludes our first 6-minute rounds. We are going to go to our 5-minute rounds and start with Mr. Brock. Go ahead, Mr. Brock.
Thank you, Chair, and good morning, Professor. I want to focus not squarely on the device itself and the software attached to it, the focus really of this committee hearing, but rather the broader issue of privacy. You spoke in general terms about this being a fundamental human right, has been a fundamental human right in Canada since 1977. I'd like to get your expert opinion, sir, on this disastrous ArriveCan app that has just been revealed to be an abuse of taxpayer dollars of $60 million plus. Now, if you can think back to the time where the ArriveCan app was heavily promoted by this government, that it's the way to go in terms of dealing with the COVID, trying to protect Canadians, et cetera. But there's a portion in the preamble when you sign up for the ArriveCan that I'd like your opinion on. And the title is called How Your Information is Used and Disclosed. Personal information may be disclosed to contractors working for the Public Health Agency of Canada and Service Canada, as well as to the following entities: other government institutions, as well as provincial, territorial, municipal governments, or international health organizations, as well as their institutions for these purposes. Personal information may also be used for program evaluation. In other limited and specific circumstances, personal information may be used and or disclosed without consent in accordance with Section 7 and subsection 8 sub 2 of the Privacy Act. Every Canadian, tens of millions of Canadians who were forced by this Trudeau government to sign up for this ArriveCan app,
Point of order,
it
Chair.
looks like
Point of
had
order,
their
Chair.
personal information wildly...
Hold on, Mr. Brock. I have a point of order, and go ahead, Ms. Khalid.
Thanks, Chair. I'm just questioning the relevance of Mr. Brock's questioning. I'm sure the witness is not called for the line of questioning that Mr. Brock has delved down.
Just hang on a second. In every circumstance that a point of order is made, I am consistent in my ruling. I did it with Mr. Housefather, and I'm doing it again with Mr. Brock. It's his time. We've got a subject matter expert on privacy that's before us here. I'm going to allow Mr. Brock to continue. He has the floor, and I'm sure he's going to bring this to where it needs to go. Mr. Brock, just Ms. Khalid, we can beat a dead horse on this. I've been chair of this committee now for almost a year and a half, and my rulings have been consistent in every circumstance for every member that sits around this table. Mr. Brock, you have 3 minutes and 2 seconds. Go ahead.
You heard the exchange. Some Liberal members don't care about privacy. Conservatives certainly do.
I object to
I'd
that,
like to get
Chair.
your
Mr. Brock,
opinion.
it's a matter of opinion, Mr. Brock.
Chair, I wasn't going to say it. I will say it now. Mr. Brock started his questioning by saying that he is going to be asking a question that is not relevant to the topic at hand today.
I'm not sure I heard him say that, but I can certainly check back. But Mr. Brock, you have the floor. 2 minutes and 50 seconds.
Privacy. So, Mr. Light, Professor Light, can I get your opinion on what I just read out to you? Is that a danger? Was
Sure.
that a danger?
I just want to preface this by stating I am a member of no political party, and I come to this believing that privacy is a completely nonpartisan issue.
Yes.
We're talking about a human right. It's
Yes.
not negotiable. It's not debatable.
Yes.
I think that the preamble that you read is really fascinating because to me it speaks to, if you remember, to Bill C-51, which was a Harper government law, created a brand new level of data sharing between government agencies. And this preamble sort of lays out how that happens. It shows you how this information flows between agencies and how it's become a quite normal thing to do. I think that dates back a very long time. That's not a new thing. It's probably been going on since before the Harper years, but I think it's something that maybe was informal and now has become quite formalized. It does scare me. As somebody who used ArriveCan when it came out because I found it easier, or I wasn't provided with paper on a plane to fill out. I think that our technologies at airports, at borders, are quite invasive. They're also quite invasive everywhere in the world. I've been to airports in Europe where I can't go to get a connection without having my face and my hand scanned. So I think our levels of invasion are not necessarily at that high level here, but that, yeah, I think that it's problematic.
Particularly with the phrase "without consent," I think is extremely problematic. Would you agree with that?
Yeah, and I think that the position that it puts a traveler in, for instance, just as in the case of using mobile forensic devices within agencies for administrative purposes, you're in a position where you can't necessarily consent, where there's a power imbalance, and so you're doing something because
one can only surmise what type of information that is in the possession right now of the Government of Canada, not used for purposes to protect that individual from COVID. Now, another issue I want to discuss. How much time do I have, Chair?
45 seconds.
45 seconds.
Mr. Brock.
You are aware that.
To the timelines.
Thank you. You're aware the Auditor General released a report. She talked about cybersecurity leaks, the individuals, the contractors not having proper security clearance. How do you weigh that, sir, in terms of an opinion?
I can't say I haven't read it closely.
You have not?
No.
Okay, the phrase is, the agency told us that the resources did not have access to travelers' personal information. Having resources that were not security cleared exposed the agency to an increased risk of security breaches. This is in relation to the CBSA. Giving contractors without security clearance the authority to gain information on travelers. What's your opinion on that, sir?
Okay.
Problematic. Thank you.
Thank you, Mr. Brock. Ms. Khalid, go ahead, please.
Thank you very much, Chair, and thank you, Mr. Light, for being here today. I'll start off by asking, so the member for Brantford Brant recently said in the OGO Committee, the Government Operations Committee, that if people are public servants, there are no privacy issues. Do you believe that public servants are entitled to privacy?
Yes, and if you look back a few weeks ago, Brigitte Bureau at Radio Cannes published an article exactly on this issue and interviewed two legal experts. I don't consider myself I'm not a lawyer. I don't consider myself a legal expert, but one law professor and one lawyer both said that employees, civil servants, do have an expectation of privacy, do have the right to privacy, even when they're using government-issued devices.
And
there's a difference between the device itself and the stuff on the device.
so when a government employee, for example, is given a device that that they use for their work, which is what we're talking about in these 13 departments, do they have a reasonable expectation of privacy on those government phones that they use, that was given to them to be able to do their work better?
I believe so.
And with that reasonable expectation of privacy and the consent piece of it, what is the role that a privacy impact assessment plays in how departments manage their relationships with their employees?
So right now, I think privacy impact assessments, they're not necessarily a standard thing. They push an agency through a line of questioning that helps them think about how to meet this balance of privacy violations and privacy protections. But that process isn't necessarily clear, I don't think, to employees. And so I think that it's there for guidance at a high level, but it's not there for understanding at the ground level.
And to be clear, employees' personal phones are not impacted by what we are talking about here today. It is specifically government-owned devices, yes? I think
this committee's spoken about a number of different possible uses. So there are uses in administrative cases for internal evaluation of government-owned phones, and then there are organizations, most of the organizations that you've had come testify to you have spoken about the use on devices of non-employees, DFO, Transportation Safety Board, CBSA, the RCMP. They use this on non-employees as well.
I'm not sure if that was my take on the testimony that we heard, but just on that, the relationship between warrants and hypotheticals, as in what could be done or what is possible versus what is actually done. Do you think that there's a break in public trust? Clearly, you have mistrust in how departments are operating these devices with their employees. How do you think we can work to build better trust so that you and others don't think that what could be done is not actually being done?
So for me, as a researcher, I want clear evidence. And so in the process of preparing ATIPs for these agencies, for their internal policies, for their use logs. Show me what you use these things for. Show me why you use them. Show me what policies exist, what policies don't. What laws exist, and what laws don't.
Now, my understanding is that all of whatever is done to employee phones is done either through consent or through warrants. Is that, do you think, not sufficient to protect an employee?
I don't think consent is enough. I don't think people necessarily know what they're consenting to.
So if consent is not enough, then what is?
I think that one, if we go back to my comments around privacy impact assessments being tools for self-regulation, that we need to have an external body like the OPC that decides whether these things should be used in the first place. And that a body like the OPC could decide what sort of processes need to be in place for people to actually make informed consent around the examination of their devices.
Do you hold that same view for private organizations as they deal with their employees, or is it just government departments that you feel need to go through these extra measures?
Do you mean corporations?
Yes.
I would be troubled if corporations were able to buy these technologies. If they were, I would have the same expectations in terms of consent.
And lastly, I just want to go through what your definitions were with respect to spyware and digital forensic software. Now, you had said that they're basically one and the same, and that's not what we've heard in testimony from other witnesses. Can you clarify your position on that, please?
Their capabilities are somewhat the same. So spyware, you have applications that are surreptitiously installed on people's phones in order to spy on them in real time. Mobile forensic devices give you the ability to access the same granularity of data after the fact. So they're not the same thing at all, but they provide the same, essentially, access to data that you would not have otherwise without having to get a warrant to the degree that you would need to get a warrant to access each connection to a cloud service provider, for instance.
And you don't have evidence to support that this is actually what is being done in these departments for now?
I don't, because, no, but I do have evidence that they have purchased the technology to do it. And for me, why would you purchase technology to be able to access these things if you're not planning to do it? These are separate technologies. All the mobile forensic devices are various softwares and hardware pieces that can be bought piecemeal. And so the technology with the capability of doing this has been recently purchased. There are licenses that are active through the middle of the summer of 2024.
Thank you, Mr. Light. Thank you, Ms. Khalid. J'entends quelque chose.
I'm hearing something on a phone. Is somebody using a mobile phone or using some kind of video? I would like you to mute all devices. Inaudible, unfortunately.
On the volume. Monsieur Villemure, pour 2 minutes et demie, s'il vous plaît.
2.5 minutes, Monsieur Villemure. Thank you, Chair. What you're saying, Mr. Light, could be source of concern, and the technology is moving ahead very quickly. Today, we have these forensic tools. Now, regarding the privacy impact assessment, is it sufficient relative to the development of technology? I do not think so. And based on all the testimonies that we've been able to hear regarding the protection of privacy, focus the attention on program. And on Tuesday, the board says that this technology had been used since 1996, even before the directive was issued by the Treasury Board. However, we had a privacy protection which predates the existence of some technologies. However, data and the capabilities are changing, and there's more and more of an ability to penetrate. Do you think that the commissioner should also change his or her level of scrutiny given the technological progress? Yes. So are you currently reassured that everything will be going as it should and the world will unfold as it should. Answer, no. And I have a much better knowledge of the situation than previously. So this is a general question. Everything that's kind of surrounds privacy, isn't it underestimated in importance? I believe so, given the use which is made of technologies and the new modes of communications. I believe that standards in communication have changed social standards and social norms. Is there such a thing remaining as privacy? Yes, I believe so, but it is threatened. Thank you so much. Thank you, Mr. Villemure.
Then we're going to go to Madame Kuzi for 2.5, and then Ms. Damoff, and then that'll complete the round. Mr. Green.
Very much. And I think one of the challenges we have is that we're only ever in these committees having these discussions kind of after the fact. We know that with the on-device technology the RCMP was using, there was no proactive disclosure there. It took some revelations around procurement for us to find that out, and we're here in the same boat. So going back to our earlier conversations about finding and really pinpointing key recommendations to this committee, with your experience on access to information on procurement, what are some ways that we can create a culture of proactive disclosure so that people have a better understanding for what the government is doing?
I think if we go back to the model where the OPC would have a role in procurement, then we have a reporting mechanism, so that instead of having agencies making up their minds about what they do on their own, that there's an obstacle there, that there's a step that everybody has to pass through where information becomes public, where a committee like this could be asked to review a certain technology before it's used. But right now, it's really all pretty piecemeal.
Yeah, it's very piecemeal. We heard that, I think, as a consistent reflection from the departments. Each of them were picking and choosing their own adventure, some of them saying they were at various forms of a privacy impact assessment. And then I also picked up that not all of them were assessing the actual tool, but their quote-unquote programs. Why do you think it'd be a problem for a PIA on a program rather than the specificity of the tool?
I think tools change all the time, and their abilities change all the time. And the programs are probably too general to capture the ability, the evolving capabilities of tools.
In your opinion, kind of having a broad look at this entire sector of technology, is it safe to say that both in the private and the public sector, this is a completely unregulated field?
Absolutely.
Is it safe to say that in light of, disinformation and misinformation and the ability for surreptitious surveillance to create profiles that form algorithms, both in the public and the private sector, that we need to have a framework in place that safeguards Canadians' data sovereignty? And maybe you can just comment a bit on data sovereignty as an effective means for protecting our democratic institutions.
I mean, I couldn't say whether or not data sovereignty is out of the scope of the conversation. I think that
I just put it in the scope of the conversation. What's your opinion on data sovereignty?
You're going to need a very quick opinion, please.
I'll put it in writing.
Okay. Same thing. Thank you, Mr. Green. A week from today, 5 o'clock, if you don't mind, Mr. Light. Madame Kuzi, pour 2 minutes et demi.
Madame Kuzi, 2.5 minutes.
Given your concerns about the lack of transparency and oversight by this current government, are you concerned that the president of the Treasury Board, the person who's supposed to be responsible for enforcing these privacy impact assessments, states it's the job of each institution, each department to enforce this compliance themselves?
Yeah, I think that's a problem, but I don't think it's necessarily limited to this current government. This directive actually originates in 2002. This was misstated by various witnesses to this committee that they thought, well, we're basing this on the 2018 directive. The original directive was in 2002, and so I think it's been ignored since 2002.
Yeah, further to your comments about the oversight and transparency, I know, for example, we are running into this problem in our Study and Government Operations Committee, where we have the individual who recently conducted the internal investigation, the Executive Director of Professional Integrity, reporting to the Director of the agency, the head of the CBSA. We've seen recently 2 data breaches within the government. On November 18th, 2023, it was reported in CTV that RCMP and Canadian Armed Forces, their information was compromised, both personal and financial, with this breach going back to information as far as 1999. And secondly, on February 12th, just a few days ago, it was reported that a subcontractor, of Canada Life also had their information breached as well. So two very specific examples relative to both public servants, government agencies. Would you say that the cloud environment and these tools that you mentioned provide for greater possibility for more breaches such as this?
Yeah, definitely. I think that if people have connections to, for instance, if government information is on the cloud and you access it through the cloud on a device, then that could be a possibility.
Excellent. You stated recently that Canada has entered an era of normalization of surveillance. Can you expand specifically beyond that, please?
Sure. I don't think we've entered it. I think it goes back a very long time. For instance, in my work looking at how we use the radio waves to do surveillance in Canada, CSIS has had the authority from, at that point, the Department of Communications, to use the airwaves to surveil domestically since 1991. So I think that surveillance is something that's always going to be within and outside government. I don't think it's necessarily that surveillance has become normalized. I think it's an expectation that it's used. I think that the lack of regulation and transparency around it has become normalized.
Okay.
Thank you. Thank you, Chair.
Thank you, Ms. Kuzi, Mr. Light. Ms. Damoff, go ahead for 2.5.
Thank you, Chair, and thank you to our witness for being here today. I wanted to talk a little bit about use of work phones. I had mentioned this previously, but in 1996, in the days before we even had cell phones, I was working at Midland Walwyn, and I had to sign something that said the use of my work computer was to be used for work only. So when we talk about consent, I think employees should have a good sense that their work phone that they're given is to be used for work purposes only. Would you agree with that?
I would, with the caveat that as technology advances, we see a real big merger of the private and the professional. And
I'm not saying that people don't use it for private reasons, but there is an expectation that your employer, whether you work for the government or whether you work for an investment bank, is giving you a tool to help you with your job, not to allow you to do something out of work. And I wanted to share with you some of the testimony that we got previously, Shared Services Canada, when they said, the initial media coverage referenced spyware. I want to assure you that under no circumstances is this an accurate description of the tools used by SSC. Investigations happen only when there's a credible allegation of employee wrongdoing and to ensure the security of government networks upon which Canadians depend, and impacted employees are always made aware of the conduct of these investigations and procedural fairness. We heard similar testimony from CBSA, where there's only a warrant. It's not when they just take your phone during a secondary screening, and it's only when they have a warrant. And then the RCMP said the media reports suggesting these digital forensic tools are considered spyware are inaccurate. And I will clarify, he said these tools are used on digital devices when they are lawfully seized through criminal investigations. So I guess my question is, do you think these people are telling the truth when they've come to committee to say these things?
No, I believe they're telling the truth, but I believe that the law, the policies have not kept up with the capabilities of these devices and what they're capable of.
Okay, that's fair.
And I don't believe employees understand that.
Well, I think employees have to take some onus on themselves when they're doing something for work. And I also think if there's a suggestion of harassment or wrongdoing by the employee, regardless of where you work, your employer should have the ability to use the proper legal tools, including with your phone, to be able to investigate allegations of wrongdoing. So my time's up, Chair. Thank you.
Thank you, Ms. Damoff. Mr. Light, I want to thank you for appearing before the committee today with your testimony. We've got the next panel that needs to be set up, so we're going to suspend for a couple of minutes. We'll be back soon. Thank you. welcome back for our second hour. That took a little bit longer than a couple of minutes, but let's get started here. I'd like to welcome our witnesses for the second hour today from the Canadian Association of Professional Employees. Nathan Pryor is here. He is the president. We've got Laura Shantz, who is the Senior Advisor, Advocacy and Campaigns. And from the Professional Institute of the Public Service of Canada, Jennifer Carr is here. And I want to welcome all three of you for being here today. You have up to 5 minutes to address the committee. I think we're going to start with the Canadian Association of Professional Employees. Go ahead, sir. Thank you.
Thank you. Good afternoon, and thank you for the opportunity to appear before the committee today. My name's Nathan Pryor. I'm the president of the Canadian Association of Professional Employees, where I represent over 25,000 public sector workers in the economics and social sciences, service and translation groups, as well as employees of the Library of Parliament, the Office of the Parliamentary Budget Officer, and as well as civilian members of the RCMP. So we're shocked and dismayed to learn that spyware has been used in multiple federal departments on federal devices used by public sector workers without following the government's own policies. The use of this spyware was uncovered, as we just heard, through an access to information request submitted by Dr. Light. And public sector workers learned of the potential breach of their rights from the press, instead of through mandated privacy assessments or any sort of proactive disclosure by the employer. So this kind of secretive behavior damages the trust between public sector workers and their employer. And Dr. Light described the use of this spyware as, quote, overkill, and, quote, ridiculous, but also dangerous. And we just heard some examples of why he felt that way. And in our estimation, the use of such software is pretty heavy-handed and is a breach of our workers' trust, of our members' trust. So the government's directive on privacy impact assessment is in place to ensure that any data collection is done through the least intrusive methods possible. And the government's own privacy commissioner has indicated that assessments are warranted whenever privacy-infringing tools are used, even when there is judicial authorization in place that some measure be used. The 13 departments in question here didn't perform privacy impact assessments before using this spyware, despite their own policies requiring such an assessment to be done. And for us, that's completely unacceptable. Je vais passer au français pour cette prochaine partie.
I'll move to French. Federal employees need to have the same protection rights as other Canadians. Their employer must treat them in a way that allows them to offer quality services to Canadians in order to rebuild trust and ensure that government workers maintain their rights to privacy and due process. We call on the federal government to make a plan to update and consistently follow its digital policy framework.
So, CAPE, my union, is here to present 3 specific requests. First, we're calling on the government to stop the use of spyware on federal devices outside of its own established rules, and to use the least invasive measures necessary. All public sector workers deserve due process during investigations. Second, we want to know when the government plans to conduct privacy impact assessments at all affected departments and publicly release the results of these assessments to help public sector workers rebuild trust in their employer after these breaches. Spyware use represents an erosion of privacy rights that no public worker should accept on its face. And finally, we call on the government to conduct a thorough review of all its digital policies to ensure that the existing policy framework is adequately robust to protect employees' digital rights, including their right to reasonable privacy, the right to be informed about any digital surveillance tools being used in the workplace, and their right to disconnect from work at the end of the day. Now, CAPE members deliver sound policy advice for the government, and they can only do their best work when the employer demonstrates its willingness to be open, transparent, and respectful of the public sector. Thank you.
Prior, Ms. Carr, for 5 minutes, please. Go ahead.
Thank you, Mr. Chair. Thank you for the invitation today. My name is Jennifer Carr. I'm the proud president of the Professional Institute of the Public Service of Canada. We represent 75,000 federal public service, some in the provincial sphere as well. We also represent IT workers. I want to start today by making our position very clear. Employees' privacy rights must be protected. Government employees, our members, are Canadian citizens just like you and I are. We all have the right to know when our information is being accessed, what information is being gathered, how it's going to be used, who has it and will have access to it, and how it's being stored and protected. And I hope we can all agree that as one of the largest employers, the federal government should set the example for all other employers to be held to the highest standard. Sadly, as you have heard, it appears that many government departments and agencies have not done so. They have failed to abide by the government's own policies and rules. They apparently disregarded the Treasury Board directive requiring privacy impact assessments be carried out before using any kind of these tools. We are talking about federal departments and agencies potentially using these tools to access text messages, emails, photos, travel history, to access cloud-based data and reveal internet search histories, deleted content, and social media activities, and possibly recover encrypted or password-protected information. Think about all the information you right now have on your phones, your tablets, your watch, or your computer. Health data, financial information, deleted messages from friends and family, or cloud-based information like your family photos stored on Dropbox, Google, or OneDrive. The idea that using an employer-supplied phone or computer means that you give up all your rights to privacy is absurd. We are deeply concerned to learn that some employers, like Fisheries and Oceans Canada, claim that the use of these tools was justified because the data belongs to the department. Your employer may own your device, but that does not mean they own your personal data on it. The Privacy Commissioner and legal experts have been crystal clear on this. The Commissioner also made it clear that even when there is a legal authorization, it doesn't mean that the departments are exempt from doing the privacy impact assessment. These assessments are critical to identifying potential risks, potential privacy risks, and figuring out how those risks can be mitigated and or eliminated. The Privacy Commissioner should make it clear that his office must be consulted before these tools are used, not learn about it in the media stories after the fact. We also need transparency around how often assessments are required to be done and what should trigger one if we need to do a new one. Technology is evolving at a faster rate than we have ever seen before. This means our privacy laws, regulations, and practices need to evolve just as fast. Moreover, government departments and agencies should be required to consult the Privacy Commissioner prior to adopting any new privacy rules, especially when they pertain to the use of intrusive software tools. Failing this, MP should amend the Privacy Act to make the requirements under law. The employees we represent are also concerned by the testimony you have heard by some of their departments. Health Canada first said that they purchased but never used these tools, before admitting that they had used them, but wouldn't say for what. Defense officials testified that it was unclear whether the privacy impact assessments were completed or not. RCMP officials told you that they were using the tools, but would only do the impact assessment later in this year. As the union representing tens of thousands of federal employees, these mixed messages heighten our concern about electronic surveillance in our workplace. In closing, I want to thank you, committee members, for launching this study. Our members appreciate your decision to look into this issue. We are urging you to make strong and clear recommendations on how government employees' personal data should be better protected. And these recommendations include: government departments and agencies should be required by law to conduct the privacy impact assessments before using any of these tools, regardless of whether legal authorization exists, as the Privacy Commissioner recommend, and that less intrusive methods be used and to gather such information as required by the Assessment Act. When departments and agencies fail to abide by Treasury directives, there should be clear repercussions and actions to ensure that they have further compliance. Second, clear guidelines be provided around what new or modified programs will require new privacy assessments, and that current ones be updated. Technology is moving at a fast pace, and our practices need to reflect that reality. And finally, the government must acknowledge that the use of an employee's device does not give them ownership of people's personal data on it. As these tools As these tools the study have been asked to investigate become more powerful and invasive, privacy protections must be improved and keep pace. We urge all MPs to come together and ensure that the government maintains the highest standard when it comes to employee privacy. Let's make our government a shining example as the employer across the country when it comes to protecting privacy in the workplace. Thank you.
Okay, thank you. I want to thank both of you for your opening statements, and more so for providing solutions. It's not often that we get witnesses that come with these type of solutions and recommendations to the committee, so I appreciate that you both have done that. Mr. Couric, you have 6 minutes, opening round. Go ahead, please.
Thanks very much, and thank you to our witnesses for being here. Now I want to preempt what seems to have been the argument from the government on a number of cases. And first, and it addresses specifically, so I want to give you a chance to answer this. The government has said, oh, don't worry, it's not spyware. And it's troubling because these are incredibly powerful tools that have access to that personal information. And then also, so I'll direct that question to Mr. Pryor, but I'll ask my second one as well, which will go to Ms. Carr, and that is surrounding it's a government device, therefore you basically have no rights, and that's a paraphrase of even questions that we heard from a parliamentary secretary in the last hour. I think you were here for that. So I'd like to ask your opinion on that, and if you can provide some context as to why, in your opening statements, you referred to it as those things, and then I have a couple of more questions that I'd like to get to. We'll start with Mr. Pryor.
Sure. Thank you for the question. I would say, whether we call it a spyware by definition, we could argue over the definition. It is technology that is infringing on our members' privacy rights. And I think that's the basic line that was crossed here. The proactive disclosure of the use of this technology, even though Treasury Board directives state that should have happened, did not happen. We learned about it after the fact. And just to speak to the issue of whether a government device is able to suspend, the fact that it is a government device is able to suspend all the members' privacy rights as such. The federal government is one of the biggest employers in this country. It needs to be setting a high bar and a high example for how we expect all employers to behave towards all Canadian citizens and their privacy rights as such. And we feel that in this case, and in many other cases it seems that we're learning about slowly, basic policy wasn't followed. The Privacy Commissioner was very clear that when new tools are developed that pose the privacy risks, as we've seen here, that merits a privacy impact assessment and proactive disclosure. I think there's very easy ways to communicate proactive disclosure of these technologies in plain language that will make workers in a workplace, our members, federal public servants, much more able not just to abide by basic standards of what is to be shared on a government device, but to be aware of their privacy rights and the potential violations of them, so that that discussion can happen before these technologies are installed.
I hate to cut you off, but it's as you know, we have limited time, and you may have heard my not so subtle advice to department heads and whatnot. Say, pick up the phone, call the Privacy Commissioner. Better needs to be done so that we can start to restore that trust, both with Canadians, but also the hardworking men and women in our public service. So Ms. Carr, and I'm
precise.
Okay,
this is Nate's first appearance, so I've been on this rodeo train before. So
I do apologize.
Yeah, you may not know that there is already a policy on using digital devices. That in that policy it says that you can actually use the government devices for personal use if it does not interfere with your work. It is done on your own time. So I'm not sure that was brought up before by anyone else. These policies, there are lots of policy suites that exist within the government sphere, but as we leave them to be decentralized and applied by individual departments instead of centralized through Treasury Board and oversight, that's where we get into trouble.
No, and I appreciate that, and I think it's an important, especially because cell phones, mobile devices have become such powerful communications tools. No longer is it just a cell phone or just an email device. It's so much more than that. So I am curious if I could hear your opinion first, and if you can offer any examples of if these investigative tools have been used to find whistleblowers or people that have been targeted because of their actions within a particular department. So specifically in terms of finding a whistleblower, I'm wondering if there's any examples, if you've heard that or could cite them. But I'd also just ask for your opinion about how this could infringe on a worker's ability to call out what could be misconduct within their department, agency, or otherwise.
I'll go first. One of the things that concerns me about some of the testimony is that they say they have the software, but they don't use it. They send it off to another department. If the technology exists and we don't know how it's being used, and they don't have to disclose when and how it's being used, that is very concerning. I can't point to a specific example, but having technology and not having any kind of disclosure on when you need to use it, any director or DG signing off, that again is very concerning. No oversight means it can be used without us knowing.
Yeah, and Mr. Pryor, was there anything you wanted to add to that? There's about a minute left here.
No, I just wanted to say that I agree with Jennifer on the points that she made, but also the employer has a strong track record here of being reactive instead of proactive when it comes to digital policy and privacy, and so a lot of Treasury Board policies are in desperate need of updating for the digital world and need to be probably constantly refreshed as we go. But I think the policy framework that we have is strong enough. It just needs to be followed more closely.
I appreciate that, and the proactive versus reactive, that's the message I think that the government departments would it would behoove them to follow. So when it comes to the use of these tools and the idea of consent with employees, we heard in testimony from the last hour about the power imbalance. Could you provide just brief context?
That's a great question. Because of when these policies were put in place, what is the consent? I don't think that when the original policy, when it was just your cell phone, they would have access to who you called, how long you did. But they haven't done it when we're using these tools for things like cloud-based. These tools will allow you to go into those clouds. They will allow you to go into encrypted, password protected. They have all your history. So that was not contemplated way back. We need to have the updated policies. I hope that you can agree that anyone, the unlimited potential for them to use this tool to find anything it's absurd that we would think that they don't know privacy.
Thank you, Ms. Carr. We did go a little over there. Trying to keep the tight timelines, respecting everyone's time. Mr. Baines, you have 6 minutes. Go ahead, please.
Chair, and thank you to our witnesses for joining us today. And thank you for sharing your recommendations. Part of our work as a committee is to make recommendations, and thank you for sharing those from off the top from both organizations. And we did hear from the Privacy Commissioner and about the use of the term spyware specifically. Initial reports referred to, and this is, I quote the testimony the Privacy Commissioner gave us, initial reports referred to them as covert surveillance or spyware. Since then, it has been clarified that the tools are digital forensic tools which are distinct from spyware. Digital forensic tools are distinct from spyware in that spyware is typically installed remotely on a person's device without their knowledge. Where we've heard that these devices are used within regulations, a warrant, and the knowledge of employees. We heard from several agencies. We talked when we asked them about, and I think I specifically asked, can you remotely access people's information with these tools? And they say, no, you have to get a warrant and physically obtain the device, connect to it, and then you can extract the information that we've been talking about. So any thoughts on that? Ms. Carr.
Yeah, so again, we have these testimonies, but it's not clear. Every department has come in and given you a different version of how they're using it. If it is true that you're handing your device off to a third party and then can be wrote, why do the departments actually buy and procure this software and have it in-house? I have some concerns about, the testimony that they've given that EOA can only be done remotely, or not remotely. The other thing is what are they pulling? Can they pull everything? Is a warrant all-inclusive, or are they specifically gathering certain information?
So we did hear that from several the agencies who are investigating something, and many of them have an enforcement piece to those departments. So it would be specific to what the investigation is, and the warrant would be specific to that, and they would only be able to obtain that information specific to whatever the investigation is. So that was the testimony that we heard. So another question I have for you is, are employees made aware when using these devices that they are for professional use and not personal use? For example, like we have two devices.
So again, I refer to the policy. I will get you the actual name of the policy, but it does say that work devices can be used for personal use if it does not interfere with the work that they're doing, if it's done on personal time. So the misconception that it is only employer device, it is encouraged by certain departments, and it has been for a long time, that you can use personal your work devices as personal as well.
So is it outlined to employees that in advance that your professional device can be your information on there can be looked at?
I don't believe so. Again, when I talk about decentralization, each department who hands out these devices would be responsible for making those disclosures, and it's not done in a consistent or manner that is gathered at the higher level.
Would that be helpful if that was outlined?
So again, it would be helpful if they made those disclosures. But again, if a policy says that you can, we really need to specify and drill down on what information would be gathered from your phone if under investigation.
So I think we've heard from you that you believe that a correct balance between security and privacy, there needs to be that measure in place. We've also heard that departments use this software for internal investigations and cited reasons like allegations of employee wrongdoing, instances of sexual harassment. Do you believe that this use is warranted?
Yes, I do believe that, when investigating that you should be using tools, but it should be very clear to the employee what you will access. I don't believe that the policies right now are clear that they could go and search in your back history, deleted, encrypted, and stuff. So I think it would be more disclosure, more transparency and accountability on both sides would be beneficial.
Do you have like a percentage of public servants, what percentage of public servants receive government-issued devices?
That I can't tell you. That would be probably a question for the departments. There is no consistent policy on who can access. It is really on an individual basis where they are issued.
Has there been like a level of privacy set that's expected for government-issued devices?
I don't believe so.
How much time? 20 seconds. Thank you for your time.
Thank you, Mr. Baines. Monsieur Villemure, pour 6 minutes, s'il vous plaît.
6 minutes, Mr. Villemure. Thank you, Mr. Chair. I'll take advantage of this opportunity to provide notice of a motion. Go ahead. That, pursuant to Standing Order 108.3H, the committee undertake a study of the ethics and compliance with the rules of professional conduct in the awarding of contracts entered into by the government and the companies GC Strategies and Cordal Systems Consulting, Inc., with regard to the ethical obligations arising from the Code of Values and Ethics for the public sector, that the committee allocate a minimum of 4 meetings to this study, that the committee invite to testify, A, jointly, for 2 hours, Anita Anand, President of the Treasury Board, and Jean-Yves Duclos, Minister of Public Services and Procurement Canada, as well as officials. B, for 2 hours, the President of the Canada Border Services Agency, Aaron O'Gorman, and officials. C, and any other witnesses the committee deems necessary. That the committee report its observations and recommendations to the House. It's been delivered in both official languages. Thank you, Mr. Villemure. That is a notice, and I gather that the motion moved has been distributed, circulated to members of the committee. 4 minutes, 40 seconds. Inaudible? Oh. I have questions for both groups. Mr. Pryor, were you surprised to hear about these practices? We were surprised that the policies that were in place were not being followed. We were surprised that the values integrated in these policies had been completely sidestepped, and we were surprised about that. We weren't surprised by the fact that our employer would have installed these types of technologies with. Okay, thank you, Madam Carr.
Surprised. So I'm disappointed but not surprised as we have decentralization of the federal public service. This is common for most of the violations that we see. There's little oversight in departments on some of these policies, and we need to have better oversight.
Est-ce que vous avez été rassuré?
Were you reassured by the answers that have been provided by previous witnesses?
Mr. Pryor?
No, and we expect much more in the future.
D'accord.
Very well. People have appeared and have said, you know, we use those tools, that we'd had them for a long time, and, you know, we'll do that assessment. Yeah, sure. The privacy impact assessment. We'll see if they do. Do you think they're sort of downplaying things? Do you think it's a cultural problem within the organization, Mr. Pryor?
Wide problem. I think there needs to be strong direction from the Treasury Board to explain exactly how privacy policies are going to be actually implemented in practice. And with that in mind, any new technology that's being rolled out that will impact our members' privacy requires these privacy impact assessments and these proactive disclosures. It's fairly clear in the directive, and it's fairly clear in the Privacy Commissioner's statements what is needed here. Whether it's installed remotely, whether it's installed...
Mais il y avait déjà des directives.
But these directives already existed.
Oui. Alors que je sais pas quelque...
They weren't followed. Listen, this cultural issue, what would you say to that?
We have departments who can decide what to do on their own without any kind of oversight. If we're not watching, then they're not doing. When it comes to the privacy assessment, I did hear, well, they said we did one way back. I would say that we need to update things so that when new versions come out and new technology comes out, that we start to use them. I equated it to like saying that we're still subscribing to Napster when everybody is now on Spotify or Apple Music. So we can't have an assessment that has been done on really old technology.
C'est une bonne... Mais dites-moi,
Okay, that's great. There is technology in place, and these things are part of the government structure. I don't think the problem is not so much the structure, because policies and directives exist. They weren't followed. Should we have more directives, more policies, or should we really work to change the culture? I listened to the witnesses, and I think the example needs to be set from above, and it's not the case. So what should we do?
Let's talk about repercussions. You now have 13 committees who said that they didn't do. Oops, sorry. There's no repercussions. It's going to take repercussions. It's going to take you taking away authority from deputy ministers. It's going to take you actually getting into the weeds and saying, hey, you didn't follow. We are going to roll back your authorities.
Et croyez-vous qu'avec...
And do you think with these practices we'll be able to restore confidence of your 75,000 members amongst them?
People who don't follow the policies and directives, 100%. We are really good at making sure that public servants are following the policies. Why are we not putting that same scrutiny on deputy ministers?
D'accord. Monsieur Pryor, la même question. Que...
Mr. Pryor, same question. To restore confidence, do you think this could help?
I agree completely with Jennifer on this one, that enforcement measures and serious consequences for breaches of privacy need to be taken seriously, and the next steps that need to be taken are entirely at the level of senior management being disciplined for allowing these breaches to occur in the first place. So we talk about a culture change. I think culture is a very vague thing to change. I think serious consequences for breaches of privacy are in fact the steps we need, and we need to get specific on what those are each time this happens.
Est-ce que vous croyez...
Do you believe that when it comes to expectations of deputy ministers, we could include a privacy aspect?
Les attentes signifiées au sous-ministre?
So again, every public service is a Canadian citizen.
Expectations communicated to the deputy minister.
To have clear lines on what your privacy is. We should expect a level of privacy. You should not be able to look at my kids' photos just because...
Je vais juste vous interrompre, excusez.
Forgive me for interrupting. quickly. Deputy ministers receive expectations from the government. Should that be included in the expectations which are sent to the deputy ministers?
Je vais prendre ça pour un oui. Merci.
I don't think there is a quick answer to be given to this question. Thank you, Mr. Villemere.
We'll play Pong on our Commodore 64. So no, I have Apple Music, $14.95 a month. I know that. Mr. Green, 6 minutes. Go ahead, please.
Thank you very much. And I'm just happy to be able to report that I downloaded the first Wu-Tang album on Napster 20 plus years ago. And now they're doing retirement like tours, reunion tours. So here we are. I want to pick up from where my colleague left off on what I think is a generally accepted notion of informed consent. Would you agree that your members, understanding the policy directive of the Treasury Board that technology implemented within the federal government that is directed to undergo a privacy impact assessment, would you agree that your members would have a reasonable expectation that all technologies would have, as per the direction of the Treasury Board, undergone that process? Would there be a reasonable expectation?
So I would disagree because of the policies that exist that say that you can use it for personal use. They haven't been clarified. But I pose to you, if the deputy ministers aren't following their own directives, how are the employees allowed?
No, I want to make sure you understand what I'm asking. I'm suggesting that there's a directive from the Treasury Board.
Yes.
We've heard testimony that departments are not following the directive. So would your membership, understanding that it is a policy that this should happen, this ought to happen, is it reasonable for them to assume that it has happened, even though we've heard that it hasn't?
Sorry, if there's a directive, the Treasury Board says all the time that there are directives that need to be followed. I expect that the departments should be following those directives. They are the senior leaders.
Mr. Pierre?
Yeah, I would say our members do have that expectation, and they feel that their trust has been completely breached because of the violation of a very clear policy on this, and they have an anxiety around using devices to which they have a reasonable expectation of privacy as laid out in policy.
And do you think that perhaps the Office of the Privacy Commissioner should be reviewing in a default way all these technologies, particularly the ones that could be surreptitiously collecting data?
Yes.
Because I bring that up because you talked about removing authority. Should they have the authority in the first place is the question.
So again, whether it relies with the Privacy Commissioner or the Deputy Minister and their department, what you have seen by the 13 departments, they scrambled to give you information. They scrambled to know where it was being used. They scrambled to provide a testimony to you. There should be clear accountability either at the Deputy Minister or it should reside with the Privacy Commissioner.
Sure. I would say that the Office of the Privacy Commissioner is the proper place to do this. I think in a lot of cases, in the case of Treasury Board directives, deputy ministers are left with their own discrepancy,
Correct.
their own decision-making powers when it's convenient for the employer, and then it's
a bit of the Wild West?
Yeah, it's a bit of the Wild West in terms of consistency of the application of policies, except when it's convenient for
Quickly,
the other way around.
Have there been any grievances?
So we don't know of any grievances, but in order for us to file a grievance, we have to know that the act is taking place.
Correct. Would a lack of grievance be a permission for them to breach the Privacy Act?
Absolutely not. Again, you can't grieve something if you don't know what's happening. The minute that you understand that's happening, you can make a grievance. But if you don't know what's happening, you can't protect your rights.
Mr. Pierre?
A grievance could be something that could move the needle a little bit, I would say, on this, and we're looking at ways to enforce our members' rights in this case. But the case is that the policies exist and should have enforcement rights built in at that management level.
Should we review the Privacy Act?
100%.
What would you like to see in it?
Again, the guidelines that I had for the Privacy Act were that the guidelines be clear around what, when and how new modified requirements need a new privacy assessment and when current ones need to be updated. And we also need to make sure that it is enforced that these software tools are being assessed before being used, and that all less invasive methods be considered beforehand.
Mr. Pierre, anything to add to that?
No, just the employer needs to take its responsibilities to its workers and to the Canadian public seriously, and this point has been made over and over again about these being Canadian citizens as well as federal public servants. So when digital policies are out of date and not respected, we find ourselves with spyware on government devices, and clearly enshrined rights are not respected. So The Privacy Act could be updated in all these ways, but we think that there are strong tools in place right now with no enforcement mechanisms and no consequences for their breach.
I want you to have the ability to answer a question that has been kind of generally posed by some of the departments, and that is that tools are being used to look into government. Do I have time? Okay. That tools are being used to look into government policy violations such as fraud or workplace harassment. So shouldn't the government have the right to look into these serious violations?
Yeah, so if they're using these tools in the way that they're supposed to or that what they're intended and under and up to the data privacy assessment has been done, we need to make sure that we heard, at least of the 3 departments, they said they have used them without doing the prior assessment. So we need to make sure that the assessments are being done as they're intended.
Mr. Pierre?
I have nothing to add to that.
So, as we kind of contemplate final recommendations, notwithstanding that likely your membership will be tuned into this issue now, what steps can we take to help maybe restore some trust from just the general feeling of having, something that is now I would argue, fully integrated into every aspect of life? Like you referenced the way in which applications on the phone. I have an iPhone. I have an iWatch. The biometrics, all the different ways in which my banking information, everything is there. How can we help in this committee restore some of the trust from your membership back towards their senior management?
Accountability. It all comes back to accountability. If we have the directives, what happens when people don't follow directives? When you're asked to do something prior to? We also need, again, like I said in my statement, the government needs to acknowledge that we're Canadian citizens as well, and that when we're using a device, an employer device, that does not mean that you have ownership over all the data that is contained within it.
Sure,
Quickly,
I think like a...
Quickly, Mr. Pryor. Yeah, go ahead.
A full review of digital policies and a mechanism to update them along with new technologies would be ideal. Also, I want to just raise this point again, that as the largest employer in Canada, the federal government has the power and has kind of pretty specific powers to be able to impose policies that do things like proactive disclosure, informed consent, and the enforcement of privacy policies in ways that maybe imposing that on the private sector does not. So we have a benchmark setting role here, I think, as one of the largest employers in the country, but also the government of Canada, to be able to do this with powers that maybe might be muddier when it moves into the private sector. But there's a benchmark setting here that matters for all Canadians and matters to our members.
Thank you, Mr. Pryor. Mr. Green, it was an important question, so I did give extra time for response, and the fear that Mr. Green would file a grievance against the International Association of Chairs of Committees. So, Mr. Brock, 5 minutes, go ahead. We're going to go 5, 2.5, 2.5. Go ahead, Mr. Brock.
Thank you, Chair. Thank you to the witnesses for your attendance. Earlier this week, the Auditor General, as you know, released a bombshell report exposing incompetence and corruption within the CBSA. And I think the most glaring problem with this report is how the government, despite its promise in 2015 to reduce the size of the use of external consultants and rely upon the professional public service. And we know that over the years, he's increased the size of the public service by close to 40%. How do you feel as union leaders, and how does the membership feel knowing that GC Strategies, a 2-person firm working out of their basement with no IT experience, simply connecting government with IT professionals, how does your membership feel about that egregious abuse of the expertise that your membership holds?
So I'm going to take that because I represent the IT workers, and I'll say we are livid. I would
you
love
are.
to come back to this committee. There's lots that I could talk about with regards to this whole contracting out. I had a member come to me yesterday this week and said, I can't even get a pencil and a notebook without 2 people, signing off on authority. How can something balloon so big?
Wow.
So I would love the opportunity to come back. I didn't prepare for that testimony today, but I would love to come back and talk to you
You've got 3.5 minutes. Can you elaborate
so-
some more?
So,
I'd love to hear more. More.
Okay. So contracting out has been a preoccupation of the Professional Institute of the Public Service of Canada. We represent professionals, engineers, nurses, doctors, all regulated professionals who take their work very seriously on behalf of Canadians. To watch things be contracted out, it leads to higher costs to the government. It was 40% higher in the report, less transparency, less accountability, lower quality of service, and most importantly for me is the loss of institutional knowledge because it is done out of house. That means that we have to consistently be interdependent on contractors to even correct mistakes that they have made. So we need to make sure that we invest in the public service so that they can maintain and deliver the services, reliable services on which Canadians depend and expect.
Thank you very much. And given the future expansion of our work here at Ethics, I'm sure that we're going to see you again, Ms. Carr. So thank you for that. Over to you, Mr. Pryor and Ms. Shantz. Same type of question. Do you have any thoughts on that?
Sure. I mean, like, this was an egregious violation of procurement policies, an egregious violation of a lot of different ways in which contracting out has kind of bloated what people generally read as the public sector, right? Like, public servants actually do not make up the entirety of the public sector. A huge amount of that is shady relationships with contractors that are sometimes needed, of course. And I'm speaking here as a policy analyst and as the president of a union that represents a lot of policy analysts. Even in that specialized world of policy development, contracting out is normal. There's databases we don't have access to. There are fields of information that we just can't have access to, but this whole element of not being able to build the institutional memory to be able to carry out our tasks in a regular way is a consistent problem. And when people talk about the bloat of the public sector, for our members, it's these vast webs of contractor relationships that could probably be done far more cheaply and more effectively and in the spirit of building institutional memory and capacity in-house. And so we don't agree that the public sector is over-bloated. We don't agree that the public sector requires a lot of trimming over the next 5 to 10 years. We do need this contractor relationship and this vast web of contractors to be severely reined in, however, because we feel that our members are qualified to do the type of work we do the best with the correct levels of oversight, and those are very stringent levels of oversight.
Thank you.
If I can just add I'd just like to add briefly, we're here today to talk about privacy. And so the minute we start adding layers of contracting out, all of a sudden we have infinite points for data breaches. We've seen with BGRS moving. We've seen recently there was another one. I can't remember the name right now. Yep. And so we see that these things start to happen, that all of a sudden when we start contracting more and more, we open ourselves to more and more points of failure, more and more points of breach. And that needs to be thought about in a holistic way of how we can minimize security, because that's Canadians' personal data, public sector workers' personal data, and data that is important to our government from security perspectives. This is essential stuff. It's stuff that public sector workers are trained on, that they know how to do it, how to get it right. But when we contract that out, we start losing control, and that's something that we need to be thinking about as well.
Thank you all very much.
Thank you, Mr. Brock. Thank you all. Mr. Sorbera, I've got you for 5 minutes. Go ahead, please.
Thank you, Mr. Chair, and it's great to be here with you as chair and all my honorable colleagues. It's been 2 or 3 years since I've sat on ethics, and I sat here for a period of time, and I always find this committee to be one very, very important in many ways, and it undertakes a lot of serious studies, I would say, and I welcome the panel members here today. First off, I want to say to the panel members, to you and all your members, all the employees of the Federal Public Service, thank you for everything you do, for not only the members of the Library of Parliament that help us out, MPs out, but for what you do for literally millions and millions of Canadians every day in delivering services and benefits to them. Also, I would like to say that we have hired folks in the Federal Public Service over the last several years. We have rebuilt it after the devastating cuts that I would characterize from the prior administration, from the Harper government. They literally cut to the bone. And we know what it was like to be a federal public servant under a Conservative administration, do we not? My question, first off, the member from Brantford Brant recently said here in committee that if people are public servants, there are no privacy issues. So I'm going to ask you, Jennifer, and to you, Nathan, Do you believe that public servants are entitled to privacy?
100%. They are entitled to their privacy. We are Canadian citizens. We do not pledge allegiance to one government. We have autonomy. We can be political. We should not be able to lose our privacy rights just because we work for the federal government.
Nathan?
I believe that as a point of principle, and I believe that's been established in policy, as Jennifer has alluded to a number of times here.
Okay. Now, with respect to privacy, I also have the pleasure and honor of sitting on the industry committee, so C27, there's an aspect to privacy in that, PIPEDA and the relevant sections and so forth. Privacy is a huge thing these days, and I understand that and using very common language, if I can say that, in terms of striking a balance. I, like many of our representatives, worked in the private sector before I had the distinct pleasure of serving the residents that I currently serve. And when you are provided a device from your employer, to utilize, it is their device, and you need to use it with some judiciousness and diligence, and there's a balance there. But I've always seen the issue that there needs to be a balance stricken, and within that, within the government operations, there needs to be guardrails within the departments, and they need to follow the PIAs, the privacy impact assessments. I'm literally learning this in the last couple hours. So, and I sit on 2 other committees, so it's been a busy week. So with the PIAs. There is an agreement that when investigations need to happen, that they should happen, and the devices and the contents of those devices need to be looked at with thing. And also taking a step back, when I enter an agreement with, if I'm working for Nathan's organization and I enter an agreement with the federal government, there is a consent that you will use this device, but you will use it responsibly. So I'm putting that out there because there needs to be that balance. If there were not processes followed properly, you need to correct those processes, internal processes, it's governance, of course. But do you not agree, like, the consent is important, the balance is important, but the notion that there's got to be responsibility on the end user is important as well?
Yes, it's a shared responsibility, but if you don't upfront tell me what I can and cannot do, if you do not disclose that you are going to go in, if I access a website to get at my photos, that you can then delve through those spider webs and touch everything that I've used, that has not happened at this point.
Yeah, I believe those boundaries are being established, and the right to the privacy of your personal use of the phone or of the other device has also been kind of established, and we're finding the different guardrails as we go here, I would say. I would say that that's not what we're talking about here right now. We're talking about the proactive disclosure of a technology that should have been disclosed to those employees using those devices. So when we're talking about informed consent, we believe that this goes way past informed consent when we have to find out what technologies are on our devices through an access to information request and not through that proactive disclosure.
How much time do I have, Chair? 35. Okay. At this time, I just want to get a clarification. When someone is hired on currently, someone joins the federal public service and has gone through the rigors and processes, what consent or what information is provided to that individual? Jennifer and then Nathan, quickly.
So it is a mix depending on the department that you work for. Obviously, I believe that you are provided with your values and ethics. That's the requirement. You have to sign off on that. But other than that, I don't think that there is a set package for every department. Again, as we decentralize and allow other departments to take over the individual policies, it depends.
It depends. Nathan?
I've worked for multiple departments, and I can tell you that it's wildly inconsistent in terms of how a new employee is trained or somebody that's getting a new device is trained and given the ability to consent to what they're consenting to. I would say that, like, yes, it is a shared responsibility, of course, but in some cases, it's felt more like the terms and conditions of a new iPhone when I'm being told about the various rights and responsibilities that I have with a government device. So training might be something that's necessary, but again, I don't think that's exactly what we're talking about here.
Thank you. Thank you, Mr. Sabera. Monsieur Villemure, pour 2 minutes et demie.
Vous venez de mentionner le code de valeurs et des...
You just talked about the Code of Values and Ethics, and it's not a very clear guide, I can tell you. I'll come back to the question that I asked during my previous turn. Deputy ministers had expectations regarding ethics, and they needed to be assessed on their understanding. I'm not sure of the success rates, but are you aware of, or do you believe that that should be a part of the assessments of deputy ministers? And so they would be assessed on practices that they implement on privacy. Ms. Carr.
When we're talking about performance management, I have lots of things to say on that as well.
But
I only have 1 minute.
If you had a checklist of policies that you said that they didn't comply with, then it is important. If they get value, how many people filled out their ethics survey, how many people, all that sort of stuff. So I think it's a bigger question.
I'm going to interrupt you because I don't have a lot of time. Mr. Pryor?
Might be one way to do this. I think consequences for privacy breaches should be the true tool that we're using here.
Est-ce que vous croyez que
We heard that it was the only way to obtain results. Do you believe that it was truly the only way to get the results using those tools?
Request was the only way to get
Non, l'utilisation de l'outil.
No, the on-device investigative tools. Because often we realize that if there's not enough supervision, there's some bad behavior, and if there was more done, then the surveillance wouldn't be necessary.
Assessment. What information are you trying to get at? So let's talk about our the time theft. Let's talk about if people are at the workplace. Can we obtain that information through other means other than going invasively through a device? That would be why the assessment exists, and it should be the primary focus of getting the data in the less intrusive manner.
I don't have much to add to that except the proactive disclosure element of a new technology being used here is really, really, really at the core of where the trust was breached here, I think, too. So keeping that in mind, regardless of the results of what the technology was trying to achieve, as much as that's a bigger conversation, I think the proactive disclosure element here, just to add to what Jennifer said as well.
Merci beaucoup.
Okay, merci, Monsieur Villemure. Mr. Green, 2.5.
Thank you very much. Often in preparing for these committees, you would probably go through a set of questions that might be asked, really important points that you wanted to make, and sometimes we fail to ask those questions. So are there any points of interest or answers you'd like to provide this committee beyond your opening statement and beyond the questions that have been asked?
So again, I think, I come to these committees. I will actually be at the Defense Committee in 2 weeks talking about contracting out. I think the overall accountability and the decentralization of responsibilities to departments has created an environment where it's hard for me to tell my members what rights they have and how they're going to be applied, what policies are going to refer to them, and how to provide them guidance. So I really would like to say that, we all work for the federal government. We have one employer. However, we have, many, many different rules and regulations depending on where you work.
I believe most of my points were made today. Thank you.
Should you have any additional points, or should you hear perhaps information you'd wish to have a rebuttal to? Notwithstanding the next session with the Treasury Board, please do feel free to submit that to the committee for our consideration, and really appreciate your work.
I'll definitely get you that directive so that every committee member knows that it is allowed.
And I'll just also put on the record with my time remaining, I'm not shocked that union reps came with solutions, and I know that the former president of the Fire Association over there, our chair, is also not shocked. Thank you for being here today. I appreciate your testimony.
Thank you, Mr. Green. That concludes our panel for today. I want to thank you all for being here in front of committee on this important study. I also want you to relay a message on behalf of the committee to your members to tell them how much we appreciate the work they do on behalf of Canadians. Okay? So, without any further business, that concludes today's meeting. I want to wish everyone a good week in your constituencies. We're going to be back here on the 27th with the RCMP Commissioner in relation to SNC Lavalin. Thank you to the clerk, the analysts, and the technicians for all their help in putting this meeting together. The meeting is adjourned.